and talk about this, the new regulation A that is passed. You know, it's a big deal in America. It's going to be the pass in 90 days. It's going to think. And Gail, you're going to come with it. You know, you wrote some article actually from Canada about that. It's very published at the CrowdFund Beat. Just give us about 10 minutes. What's going on about all this regulation A plus? It's mini IPO. They used to go and they raise about $5 million. Now they can do about $50 million in America. I think somehow it gets everybody's attention, so not many people go to it. We're going to just quickly discuss, if I may, just 5 minutes each, then we're going to wrap it up. Thank you.
I'll start off here. Have a seat here, Joseph. Let me just start off. The concern is when you're using social media with raising capital online. So Oscar is bang on that. You got to be very sensitive on how you do that. But using social media to develop an online presence, develop followers, connections before you raise capital, that's important. They work hand in glove. And I just want to make sure that that's clarified. But there have been problems when people start using social media online to raise capital, etc. Then you get into problems. So I just want to make sure that people understand the divide here. So Reg A Plus, what do we care what it is? Canada here, it's an American thing. And I'd like to set it up and then ask my two colleagues here to kind of expand on some of the questions. What's going on in terms of Reg A Plus? There's Regulation A in the U.S., and I'm not a securities attorney, neither is our. So obviously, anything in our comments are our own in personal capacity. We ask that we speak to U.S. securities lawyer if you really want to go down this path. So the bottom line is this. Regulation A was something that was under the U.S. Securities Act. It was not often used. You could raise up to $5 million. And it was largely subject to blue sky or state laws. Imagine going to every province, every state. I think there was about 12 deals done, a handful. My colleague that was going to make it today, Alex McCormick from Venture Law at BC, she's very knowledgeable on this, and I think she's actually done 4 or 5 of those deals herself. And she's been following this, and she's been on various ABA committees. So she's literally, in my mind, an expert on the topic. But what happened and why this is such a game changer is everyone's following crowdfunding in the U.S. Title III. It's not going anywhere. The SEC has stalled it. The FINRA has stalled it. They put stuff out. And what's happening is each of the states are doing their own crowdfunding. And that's what you heard earlier referenced as intrastate crowdfunding. Don't quote me on the numbers, but let's say there's about 22 states.
23 Arizona just came out.
Yeah, that can do it, and there's a whole pile that are pending. So it's almost like the SEC and FINRA said, this is small amounts of money. We should not be getting it. They're kind of dragging the puck on this, to use my hockey analogy. And all of a sudden, Title IV of the Jobs Act comes out, which everyone's kind of on the street calling Reg A Plus. Okay? And what it is, and what's unique and why it's important for Canadians, Canadian companies, is it only works for U.S. domiciled companies or Canadian. No other countries in the world. And it has cross-border opportunities. I'll ask these gentlemen to get into specifics, but just so I have your mind trained on what the opportunity is. This is going to blow up in the U.S. mid-market, okay? Because you can raise up to $50 million for what are called Tier 2 companies. They're free trading shares, and at the $50 million level, it's reviewed by the SEC. And at Tier 1, it's going to be a coordinated state review, which raise up to $20 million. So if you look at it, you're going to have the regulators look at it. They're going to sell it to Americans. They're then going to want to come up here and maybe work with an exempt market dealer. So as an investor, you're looking at, wow, I'm going to get access to certain deals that I've never seen before in the U.S. Southbound, if you are a company looking to raise capital at that amount, you're going to look, wow, I'm going to raise capital in Canada, and I'm going to also try to raise capital in the U.S. where it can be free trading. I'm going to stop. We're going to get into some issues and concerns. This just had a couple weeks ago, but I'm going to ask Joseph to kind of, because he's been following this as well, and Gil to kind of give their comments of how does it work, what's the basic structure. Then we're going to get into what does it mean for Canadian companies, what does it mean for investors. So Joseph.
I'm actually one of those rare people that actually owns stock that was originally sold on a Reg A offering. I've actually got it framed in my living room. It's my stock in the Green Bay Packers. I just had to say that. So Reg A is a different from Reg D. Reg D is the traditional exemption used for private companies. Reg A is a low volume traded public company that is exempt from a whole host of the extraordinarily expensive filings that are required for a public company. And it was never used because you had to file in every single state that you were going to solicit investors, and there were some states like Montana that never would. So we talked about 13 jurisdictions, and to do a Reg A plus or a Reg A offer, you had to file in 50. And they each could charge money, and they were all merit-based reviews, which meant that you were sitting with a regulator who was deciding whether or not it was a good investment, and sometimes that was really great because it helped improve the investment, and sometimes it added costs and time, which made it unreasonable. So they federalized it in two ways. Tier 1 allows you to raise up to $20 million with unaudited financials, but you send it through for a merit-based review, one-stop shop for all the states. So all of the state regulators have a national association, and they've created a website where you can upload automatically into that website, and it will be reviewed by one of the association's staff, and within 21 days you'll get your answer back on whether you can or whether you have additional information that can be filed. And during that 21-day waiting period, you can do a test the waters campaign, which is to issue basic general information and start pre-registering investors who would be interested in the offer once it was live. Once you've done a Tier 1 and you're feeling good, then you can go to a Tier 2. Some folks might jump to Tier 2 right away, but Tier 2 allows you to raise up to $50 million with audited financials. So there's two tiers of audited financials in the United States, and it's the easier one of the two. And in both cases, it can be an unlimited number of unaccredited investors, but all of the other incorporation rules about how you work with those investors and your reporting requirements, especially over 2,000, kick in. And in Canada, you have similar rules. So the investors in that situation.
So just a second,
There's
just
an
a key
exemption
point,
on
the
that.
2,000, that 2,000 investors, it's a US rule. But I just wanted to appreciate what you just said. You can test the waters of your company. 21 days, the states are going to look at it. It's a coordinated review. It's just like a principal regulator. So can you appreciate that if you're real estate or a manufacturer and you're looking to raise up to $50 million, that's why they're looking at this as the new crowdfunding, the real crowdfunding, and you throw it on a portal. They believe this is going to open it completely up. And the thing is, you can sell the accredited, but to individual unaccredited investors, there's a percentage of 10% of income or assets. So that's why they're looking at Title III. It's kind of being abandoned, and this is the real crowdfunding. And it was backed by the SEC when they just launched it, or gave the official last couple weeks ago.
So, and then the key is on the 50 million, it's going to the SEC, but it's not going to the SEC for a merit-based review. It's going to the SEC for a compliance, dot the I's, that you filed all the forms, 1A, and other forms properly. So platform providers that are Reg A compliant have the automation for the filing of those forms integrated with the different required state and federal databases. They have the automation for the periodic filings that a Reg A issuer is required to do. They have built in these systems for ensuring that investors are exceeding their caps. So all of those sorts of things are what a platform would say when they report to be Reg A compliant. What's really important is in Reg D, which was the private placement, two quick things. In Reg D, which was the private placement, any company from around the world could raise money in the United States under a foreign company exemption and raise money in the United States. And they specifically said for Reg A, only US and Canadian companies. So it's a huge, I believe it's a huge opportunity and a great opportunity for us to create integration in the markets on our first tier so that folks are able to get the best deals out of the gate. The other important thing is that the exemptions that many of the portals use for registering as a broker-dealer in the United States are all Reg D based. They're not eligible for the same exemptions in Reg A. So that is great for those of us who really believe in the due diligence and the compliance infrastructure that a registered intermediary plays. So all of the Reg A offerings in the United States will be working with a FINRA registered broker-dealer, which makes the link then to an exempt market dealer in Canada much easier and allows for cross-syndication of deals, and it allows for transferring access to the know your investor, but also know your product stuff. So that's really what's exciting about this, is really opening that border to allow for a free flow of capital.
So Gil, I know you wrote an article on that. Maybe you can share your insights, what you thought about this.
I love some of the issues that Reg A Plus brings to the fore, but I want people to conceptualize this is an exemption that, as written and as the Canadian laws apply, primarily is going to be for Canadian public companies on TSXV that do joint listings in the United States, because it's going to finally allow them to do it in a not terribly expensive manner, and they're going to be able to do it cross-joint with a U.S. broker-dealer, and that's going to be a fabulous opportunity. With respect to private companies, you're going to have an interaction with OM exemption, but there's some problems of doing a cross-border deal with an OM exemption on the Canadian side and a Reg A Plus deal on the U.S. side. Now, the OM exemption is great because there's certain things that allow you to continue to do both. The OM exemption requires audited financial statements, which Reg A Plus requires, and you'd be able to do them both under Canadian IFRS, which is Canadian accounting principles for public companies. So you could technically, kill one bird with two birds with one stone. And you would have to have periodic reporting. In the United States, you'd have the additional half-year reporting. In Canada, you have annual reporting. So it wouldn't be that much different. And so the only difference where you get really, really issues, and one of the issues that I raised in my article, is in two places. Currently, the scenarios in Canada, other than for public companies, is that if you place your securities through any of the exemptions we talk about, they're not freely marketable. That means you cannot resell those securities unless you qualify for another exemption. What that means is you can offer them to the great public, but if you want to, if that person wants to resell those securities, they have to find, probably the most common one is an accredited investor.
So Gil, just on that point to be clear, so they're free trading in the U.S., but they're not free trading here. Big difference.
Big problem. So that means all of a sudden means there's going to be no trading here, and trading is going to have to go down there. And how do the issues of doing that would be complicated. The second is the issue of a number of shareholders. And this is an issue that we've talked to some of the regulators. There's a big issue in Canada as they're developing the rules, is that in Canada there's a private issuer concept that if you have more than 50 shareholders, all these other exemptions from reporting sort of cease to apply. And one of the primary ones is the tender, or issuer tender bid. I always say tender offer, which is the U.S. thing, but issuer bid, takeover bid. That kills your exit. There's an exit. If you sell your company, your private company, and you have less than 50 shareholders, you don't have to go through all the complicated tender offer, tender bid rules of offering the deal to somebody. In layman's terms, that means that no private person is going to come and buy you if they're going to have to negotiate a deal with you and then offer it to everybody else. So, which is a tender offer rule. To maximize the value of the shareholders, you do a deal with some of the major controlling shareholders, and then you have to put it out to tender to see if somebody can do better. Well, no private acquirer is going to do that, because they are going to want to negotiate a deal and spend the money and then be able to close on their deal, not do all the work and then have somebody else offer $20 more and take the deal from them.
Just to add to that, in terms of Ontario, they had the private issuer exemption where you didn't want to go past 50 because there was no other available exemptions other than next step up is accredited. But the good news is what Ontario's recently done is it's introduced a close family and friends exemption, and it's introduced other exemptions, so there's not that big gap. So Ontario has responded. That is good news. So today, as a securities lawyer, we're very concerned that if you use your private issuer status, you can't go to family and friends and all these other things. But as Ontario introduced these new exemptions, it becomes less of a concern. And just to the point in terms of If another company is going to buy out your company, do a takeover bid, that's, as tender offers US concept, that's Gil identified. All there is there's an exemption that, turns on whether you have 50 or more holders. I agree it's an impediment, but I think that perhaps you have to apply for exemptive relief or otherwise that you can deal with it. But Gil is absolutely right.
There's ways around
It is a roadblock.
There's ways around it, obviously, but it just makes it much more complicated. Like, for example, for us, we were so scared of going over 50 shareholders, we actually created a special class of securities that was redeemable at the option of the board in the event of an accepted acquisition. So there's ways around it. It's just it takes more sophisticated people, many more legal costs, constantly speaking to lawyers to be able to get around all of these issues. It just makes it more complicated, more costly.
Yeah, the one point that Gil identified with public companies as an opportunity for public companies is the fact that here's the problem. If you're a U.S. company and you get listed on the over-the-counter on NASDAQ, there's a rule that deals with OTC issuers in every jurisdiction other than Ontario that if you sell more or less to a Canadian, you are deemed to be a reporting issuer in Ontario, a public company. You got to start filing. This is a big issue. If you are a public company here, it's not an issue. So I think where we're going, because I've had certain discussions with regulators and Reg A Plus, is I think that the regulators will have to look at it here and say maybe there needs to be some sort of blanket relief that other provinces do. Ontario doesn't do that. But maybe there has to be some sort of accommodation to allow an integrated offering. There's other more complicated rules out there because if you sell outside your jurisdiction, whether you're Ontario or Alberta, you still get caught by your local rules. So even if you think about it, if I'm subject to, let's say, Alberta rules and I'm selling to the US, what exemption is available? So we keep talking about the OM exemption, but it's not available for a company in Ontario. It's very legal, but I'm just saying that the opportunities are there. It's still early days. The point is, if you're an investor and you can invest in these things, you're going to see the quality of companies increase. Because many of the criticisms were the U.S. companies coming here, why? Like, why can't they raise capital in the world's largest capital markets? But all of a sudden, you get a Reg A Plus deal. It's vetted by the regulators. You work with an EMD. The comfort level of that transaction overall has gone up. So that's why, and the fact they involve Canadian issuers, that's why we're looking at it saying, this is the game changer that they're claiming it is. And you'll see more of it as things progress. I think, speaking to Joseph before, he said a lot of the portals that he's working with are now shifting into Reg A Plus deals. Any final comments, Sheldon?
My final comments is I think that, just to point out, from where I see it from our perspective, I think Reg A is a little much too big for us, for small private companies. But I cannot emphasize enough how the ability, you have to see this as an evolution. The guy here from Israel was talking about his platform, our crowd. Well, venture capital is not really viable until you're worth about at least $5 million. Because they need to do at least $1 million deal. They normally don't invest more than 20% of your capital when they do the deal. So you're looking at a minimum of $1 million deal for a $5 million valuation. Where I see, like, for small companies like us, where real equity crowdfunding fills the space, is it fills the space between your ability to do venture cap and other deals. And of course, there's going to be, you're going to be having to raise capital, but the really small ones is where you're really accessing the capital that nobody's giving you. Because you're not yet a commercial, you're not yet treated as a commercial company. So the commercial lenders won't lend to you on a commercial basis. You're not really yet at the first venture capital round, even if you were an internet company. And you're like in this gray land where you can't access capital. I think that is really where, for small companies like us, the equity crowdfunding exemption, the OM exemption, and even the accredited investor exemptions are exemptions that allow us to access that capital to continue to get to that stage where we're able to do the big deals, which we're several years away from being able to do.
Joseph, final comments?
Just final comment. Each of these are different options that create different tools for companies. And the trick is finding the right tool for the company, for the personality of the owners, what their exit strategies are, what their goals are. Reg A Plus is a public company, which creates very different requirements than a private company, especially for the owner. reporting is very different. So it's great to just make sure that as portals emerge, finding and soliciting, curating offerings, it's really this process of matching the right tool with the company and yeah.
Yeah, well, we're gonna stay around. I just want to say,
If anybody has any questions? Thank you, everybody. Thank you very much. You guys have any perspective? Just